Alec.
Good morning, Paul. How are you?
Good, thanks.
So I just have a question regarding these, and I'm just going to call them these tweaks that don't seem to do any harm, but I'm wondering, in terms of the work that you're doing, what impact does that have? And are there time sensitive issues that we need to know about? Because I also want to respect the work that you've already done before. So, you know, before we send them someplace else or make another change, I just need to understand the timeline and the time sensitivity for those things.
Yeah, I feel like we have the individuals who've been working on this still part of the committee, and I can reach back with them. I think we can, I suspect that this was not analyzed because the focus was on just removing the gendered pronouns. This raises a new issue that I suspect was not on our radar. So I think it can be addressed, or at least better articulated in coming back the next meeting. I hope it can be pretty quick. I at least know the subcommittee chair who's worked on this. She and I are working on some other things, so it's something we can probably work through.
Okay, so there's one made, there's one been seconded, there's a friendly amendment. Is there some second to that?
I withdraw my amendment, and I think that yeah, if it looks like the chair CrRLJ is saying that we can always there's time to be able to fix this and do it right. So I would seek to do that.
Okay. Alec.
So I make a motion to postpone action on this to our January meeting to give this group time to take in consideration and do the kind of additional checks that I think have been brought up.
Okay, I mean, the one made been seconded yet, or?
Second, I will second it.
Okay, there's one made, one seconded.
Didn't we
Any
have a
discussion?
motion previously made and seconded that we need to vote on first?
This is a motion to table, so that supersedes taking action. It's actually saying we will postpone taking action to the next board meeting as opposed to this one.
Yes. Okay. Yep. Jordan.
I'm going to suggest not postponing this. I think what came to us is a good proposal to change the pronouns to, solve a simple problem in there to make it consistent in the rule. What our discussion has been on is on something that's tangential to that and related, but don't let the perfect be the enemy of the good. This is a quick fix to a problem that we have. Maybe there are other things that this rule needs to address and the court systems do broadly, but there will always be that in every context and every decision we make, because our courts have lots of little things we can do to improve the systems. So let's not forget that this is an easy win.
I will note that what we are asking the committee to do is not changing a few words. They will basically have to rewrite the entire criminal rules that refer to defendant throughout. So perhaps they can do that by using a defined term, the ham sandwich. But it is not a trivial thing to try to use a laundry list in place of defendant throughout these rules.
Sure, Kevin. Thank you. Yes, yeah. Matthew.
Thank you, President Clark. I agree with Governor Couch on this one. I feel like we should pass this today. And I guess I'm a little confused by the discussion about replacing defendant with participant and so forth, in that it sounds, if I understood Judge Flood correctly and Governor Adewale, that this is already happening with the language that's in here. So I'm just not sure what, I mean, maybe, I guess I just haven't heard the argument of what changing all this language would do for what's already happening. So for that reason, and also for the reasons articulated by Governor Couch, I don't think we should table this. I think we should pass this today. And if there's further work to be done, then the committee can do so. That's my feeling.
Thank you, Matthew.
I agree with Governor Dresden that we should not table this discussion today. And my reason being is, I think what the committee is trying to address in these particular changes in the rule is different, has a different substantive effect than what we're discussing as a partial go back and review. And my feeling and sentiment towards what they're trying to accomplish with these changes is a sense of inclusion and recognition within the law that is supported in other statutes that have been amended in the same fashion. So, you know, from the perspective that I'm not necessarily saying that there may not be amendments that need to be made, but for purposes of the underlying policy that I think they're trying to achieve with these changes, I think that that's an important change to be made and recognized and deserves fair attention and to be done.
Okay, Lauren.
Thank you. I agree with the current sentiments. I think that we should approve this. I also question whether if the Court Rules and Procedures Committee goes back and looks at this, whether they will be able to have a recommendation 2 months from now about changing language. There's many different participants in the criminal justice system. They're not all prosecutors and defendants. Victims are participants. And so I think we should be really cautious before we change language to make sure we're not being ambiguous. I don't want to confer some sort of discovery obligation on our victims. I think that would be contrary towards the goal of the criminal justice system. I do support inclusion. I just think we need to be very cautious about the language that we use, and it'll probably take more than 2 months to make sure that we don't have unintended consequences.
Mr. President, thank you. Governor Couch is running away. I want to say thank you to Governor Couch. This is an important issue, given the life at stake with regards to the fundamental of this issue and the impact it has on people. I do agree that the therapeutic court needs to be able to have a rule change with regards to the practice in those courtrooms. And that is an issue that the therapeutic court committees in our state needs to probably walk through WAPA and walk through the WISBA court rules to be able to do that. Regardless of whether defendant is changed to participant or not, every therapeutic court practice and procedures, virtually every therapeutic court practice and procedure in our state, starting with Spokane Community Court, Olympia Community Court, uses participants to designate people. In fact, we are direct cited. We are not, most of our cases are not from prosecutor's office. They are direct cited by the police officers into community court in Spokane, for instance. So given that peculiar situation, I think it's a process that needs to go on its own. I believe that perhaps we need to deal with that issue separately, because I do see the danger that people have to go through, and the idea that, you know, you've changed your name, but the court keep reminding you of who you are not, because they believe that they know you better than you know yourself. So because of that substantial point, I think that we should pass this, and I'm going to urge the Therapeutic Court Committee to approach the Rules Committee of WISBA as well as the DMCJA court rules, and I'm sure that, Governor, I'm sure that DMCJ's liaison is going to bring it up in the meetings, and it's going to be very helpful to us to also continue on that trajectory to address the issues of therapeutic participants being having an inclusive language, to encourage them to continue to do the work they needed to do to be part of the community. So I agree that we should not table this, and so we should proceed with making this amendment today. Thank you, Governor Couch, for straightening me out on that.
Okay, I see him. Okay. I will start with, Brett, please.
Thank you, Mr. President. So I support tabling this. And as a liaison to our LGBT section, to the Q Law and to the Q Law Foundation, I've been working tirelessly to get pronouns added to our directory, to work on gender neutral language. And if I'm forced to vote on this today, I'm going to vote no, because his or her, the defendant is not the replacement for his or her, it's they, them, their.
That's true.
And, you know, again, without knowing what we've heard from a judge who works with these rules and gave us specific examples when defendant is not appropriate. You know, I would be more than fine if we want to go ahead and remove the word defendant and change it. You know, I'm looking at one that says the general nature of his or her defense, the general nature of their defense. Because yes, you do have the word defendant already in the heading of B, defendant's obligations. But again, we are seeing a change from our state legislature in led by one of our own members about the term of felon. And I mean, we are looking about how these words have an impact. And if we want to change gender neutral, if we want to go gender neutral, fine, but let's not go and add in another powerful word of defendant. And I'm going to be hyperbolic and say 52 more times, when if that's what we come back 3 months from now and change, we have to amend that and go through and redo it 52 times. As where if we end up wanting to get rid of the word defendant and change it to something else, we only have to change the heading in B. So I oppose the idea that to become gender neutral, we're going to get rid of his or her with the word defendant. If we want to go gender neutral, let's call it they, them, their, as the sentence would require. So I would much rather not vote no on the underlying proposal. I'd rather postpone, get more insight, work with more stakeholders that haven't weighed in, and then come back. But if that's not an option, I will be voting no on the underlying motion. Thank you.
Thanks, Brent. Paul, next.
Thanks. I wanted to clarify one thing, particularly in response to Governor Stevens' question on timing. One is that I understood the question to focus on this particular rule, which I have concerns as to ambiguities that might be created if we add participant or some other term that I think would need to be sorted out. The bigger question of changing the term defendant throughout these rules is a bigger question and does require more work from the Court Rules and Procedures Committee. I would note that this is an off year with respect to the criminal rules of limited jurisdiction. So it's not something that we're going to have a dedicated committee to for, I believe, 2 or 3 years. So that can affect it. I can maybe put it into a subcommittee, create a subcommittee or subcommittee X, but that does pose some problems if as far as timing. With respect to these other courts, the thought that comes to me is maybe that is dealt with currently and maybe needs to be dealt with within the local rules of each of those jurisdictions as they use different terminology to suit the needs within their courts. So I don't know how that plays out within this rule statewide, but I just thought that might assist in some of the analysis as how it would interrelate with the local jurisdictions as they use their own terminology and come up with use other ways to go about it.
Great. Thank you, Paul. Alec? No? And done now? Oh, I'm sorry. Okay.
I would just say that the term defendant to me seems gender neutral. So I've defended lots of women, I've defended lots of men, I've defended out of them, they, theirs, and I don't think that this causes any problem.
Thank you, President Clark. I guess I just look at this more of what is the problem we're trying to solve. I think the issues that are raised here are significant in the sense that there does need to be some global change from the criminal standpoint. And I think that's addressed maybe in individual courts better. I don't think that's necessarily something we should be exploring in the court rule. As far as I do agree that defendant is a gender neutral term. So if that is, again, if we're looking at the problem we're trying to solve here, she, her, them, they, I'm not aware of any other pronouns, but I think you said there, Governor Williams-Ruth, those are all encapsulated in the word defendant. And I guess it can appear to be repetitive in some ways in these sentences. However, I think it solves the problem that's being posed as far as this particular rule.
Thank you. Okay, seeing no more hands up, I guess we're ready to vote on the, okay, so there's one made right now to, I mean, stall this, right? That's what I meant. Yeah, sorry. Yeah.
So I will restate the current motion on the table is to postpone action to the January meeting to give the committee time to consider the feedback.
Alec?
Yeah, since I was the mover, and I'm not sure my seconder still wants to be there.
Not anymore.
Okay, Mr. President, I'm going to withdraw the motion. But I think there's been a lot of discussion, so I want to make sure people understand why I'm withdrawing. So first of all, I asked the chair about time sensitivity on whether or not they could take up the matters that were being discussed before coming to us. And I was very concerned about that. It appears from the conversation that, and Paul, you've done excellent work for as long as I've known you on the various WISBA committees. So I think you take into consideration things additionally that you may look at and do and even coordinate in terms of presentations to other groups, as you're moving forward with this motion. So I also know how to count, so I'm not going to waste the time, and I don't even have a seconder anymore, so there's no point. But I think you know what we're asking for you to do in the future.
So can we do that then, Julie, without a vote then? Can the motion? You can. Okay, great. Okay, then that would go back to the, one then made.
Yeah, the underlying motion was to approve, was just motion for approval of the recommendation.
Okay, one made and seconded, then hearing no more discussion. Oh, yeah, let's vote.
Governor Adewale,
Aye.
Governor Angelville, Governor Boyd,
Aye.
Governor Couch,
Aye.
Governor Dresden,
Aye.
Governor Fay,
Aye.
Governor Kading, Governor Wynn,
Aye.
Governor Petrasic,
Aye.
Governor Pertzer, Governor Rathbone,
Aye.
Governor Sayani,
Aye.
Governor Stevens,
Aye.
Governor Williams-Ruth.
No.
Eyes have it then. Okay, we're above time. I believe let's take a let's break. Let's reconvene at 10. Does that sound good?
Are we going to go into executive session?
Oh, yes, yeah, we are. That's, announce that.
So when we reconvene at 10 o'clock, we're going to be moving into executive session. This was currently planned for after lunch, but we're going to move it up. So we'll come back at 10 and we'll move into executive session.
For how long, Tara? Sorry.
Let's see. We're thinking about 25 minutes and we'll make a specific announcement, but we're thinking about 20 to 25 minutes.
Can I ask now, or is it untimely? What on the agenda is an executive session?
So there's an executive session scheduled for after lunch to receive legal advice with regard to the Legislative Review Committee recommendations. This was added to the most recent amended agenda.
Okay, we're back on, and nice. Okay. All righty. Yeah. I would want to hear from her.
All right, we have a comment from Nancy Hawkins. Go ahead.
So it's my understanding that the governors are going to shortly go into executive session to discuss the agenda item regarding the Legislative Review Committee's recommendations. And preliminarily, this piece of legislation is not something I care about. I don't do business law. My objection is process. As you probably know, I am a strong opponent to executive sessions in general, and certainly surprise executive sessions too, which I guess was part of the, it kind of reminds me of Brent's comment earlier, what was it, ambush versus surprise? And to me, this seems like an ambush of the business law section. Reading the materials, and I did watch the Legislative Review Committee when they discussed this, trying to stay awake, since again, I don't do business law. But they did a very thorough presentation. They clearly put a lot of work into it. And your materials for the BOG meeting also demonstrate the amount of work that was put in, the amount of time that was put in to their recommendation. Their recommendation for a bar-initiated legislative change was ruled on unanimously, approved by the Legislative Review Committee. The agenda has been submitted a week ago. It's been a couple amended agendas have come out since then. At no point on the agenda was there a reflection that this was coming up in executive session. In fact, if I remember correctly, it's listed in the agenda as, as an agenda item to approve the recommendations. So it begs the question, does the business law section that this is know that this is even going into executive session? In executive session, will they have an opportunity to defend their own legislation under whatever the issue is? Presumably GR 12, but that this is a process where they should be involved in defending that. And just in general, this is not a good way to deal with legislative matters. The people that come to you, so first of all, it's very rare for us to have proposed legislation as opposed to comments. But when there is proposed legislation and people have put what appears to be maybe hundreds of hours into something, they should have a right to have it voted on in the manner in which they were told it was going to be voted on. And if there was a GR12 issue, why wasn't it raised at the legislative committee level where they could have dealt with it? So I would ask the Board of Governors not to go into executive session, to go forward as the agenda sets forth. And if there is some disagreement with the proposed legislation, hear from that section. Thank you.
Thank you, Nancy. I just want to announce.
All right, on behalf of President Clark, I'm announcing that the board will meet in executive session beginning at 10:06 a.m. to discuss legal advice relating to possible board action. Executive session is permitted by WSBA bylaw Article 7B7A4 to discuss with legal counsel representing the bar in litigation or potential litigation to which the bar entity, or an employee or officer of the bar or member of the bar entity is or is likely to become a party, or to have other privileged or confidential communications with legal counsel representing the bar. The executive session will end at 10:25 a.m. The board will resume public session at that time. If the executive session is going to be extended, we will make a public announcement of the time that public session will begin. So I would ask those who are not participating in the executive session to go ahead and leave the room, and I will move us into a breakout room online.